If I may, Mr. Chairman, again, Harry Ward, Deputy Attorney General, and I'd like to refer to, and the council will show this to me, under the NAC 50, Chapter 501, deals with continuance. Let me just read it in there. So this is NAC 501.175, continuance. Number one, except as otherwise provided in subsection 2, the date of the hearing may be continued once by a written stipulation from the appellate and the secretary of the commission. Number two, the date of the hearing may be continued more than once if the moving party submits a written motion for continuance to the commission. The commission will grant the motion only if A, good cause exists to continue the hearing, and B, the continuance will not prejudice the non-moving party. And what I'll do is I'll go get my NAC, and this way, if you guys need to read it and pass it around, I'll give it to you.
Council. So we have a copy of that we can look at?
That's what I'm trying to get to you
Okay.
guys.
You can have mine.
Then, here's another copy I just circled. This is.
just waiting for you guys to shuffle through your papers and figure out how we want to deliberate this, because we are on I. Commission will deliberate and render orally.
This is the problem.
Okay, so we've had closing arguments multiple times now. We've moved on to I, but now we need to go back to some more clarification. So we need to bring back the department for questions and possibly the plaintiff for questions. And if we do that, then we open up the cross-examination again.
Harry Ward, Deputy Attorney General. Once again, going back to the procedures, I don't think that there would be any problem with the commission reopening the hearing if both parties agree to it, and these would be going back to questions concerning their motion to dismiss, appellate's motion to dismiss. That would be also based on, I guess, the new information in NAC that basically was read into the record in which you have now before you. Is that correct?
Right, that's exactly right.
Counsel?
I stipulate to that. We want to be accurate and what's fair.
Okay? And the department's all right with reopening the hearing? Okay, we'll reopen the hearing. Commissioner Macbeth, you have some questions?
Yeah, this is for Rob. Chief Finance. Okay, I'm referencing Council Mr. Wright's letter of November 26, 2013 to the Board of Wildlife Commissioners, where he is consult with him with regard to a hearing date to accommodate his calendar. Was there any correspondence by the department after this letter, or was it just phone calls?
It was phone calls.
Okay, so no additional,
It was an oral contract, so to speak.
Right, and under the motion to dismiss that we were provided on page 2, it talks about on the 26th day of November 2013, certified mail was sent to the Board of Wildlife Commissioners noticing an appeal and requesting a hearing before the commissioner. Robert Bonamici called counsel Jerome Wright and advised him that the commission was meeting in Las Vegas in February and in March in Reno, Nevada. Council selected Reno, Nevada, as his client lives in Fallon, Nevada, and this matter was set for the 21st day of March 2014. So that matches. It was basically a verbal consent, but I don't, my understanding, unless there's something I'm missing in either of these two packets, is there was nothing in writing other than the November 26th letter from Mr. Wright.
okay, so I just wanted to get the facts out, so that's all I have of the council. Is there any?
Nope, I'm fine, Your Honor.
Okay. Now, I have a question again of the day. In my mind, now looking at a NAC that has a specific provision as to how to continue this hearing. And there was only one request, and so it's NAC 501.175. It basically reads, except as otherwise providing subsection 2, which does not apply. The date of a hearing may be continued once by a written stipulation from the appellant and the secretary of the commission. So now what we have is we have a specific NAC with regard to continuance, and we have the statutory provisions in 253B as to the ability of parties to enter into agreements to continue. And so where does that leave us as to that conflict?
In regards to the conflict, since NDOW has their own regulations specific to issues
you would look to yours, and if it is not in yours and ours, then you would go back to 233B.
Okay, thank you.
Okay, any further questions? Any other questions from the department? Else, council, anybody? All right. Are we comfortable with moving on to I now? Commission will deliberate and render oral and findings of fact and conclusion of law. Are we ready for that?
I think we're ready for deliberations.
Okay,
You want me to go ahead?
go ahead.
Okay, through my questioning of the parties, I pretty much, in my mind, got the facts nailed down. And I have, in my mind, and based on the facts, believe that procedurally, we are good, that the department followed the proper procedure up until they gave the notice of November 14th. So they issued their notice of November 14th. And so I guess I need to ask the rest of the commissioners, do any of the commissioners have any questions with regard to getting to that point and the number of points? Because, I believe that the original December 2012 letter, while the department says that it was 11 points, I think that's somewhat questionable, but nevertheless, I don't think it's fatal because I think there were 9 points on the letter, and that met the requirement to then send out the letter to Mr. Felton. Mr. Felton did come back and show that he had taken the hunter safety course and at that point gets credit for a reduction of 4 demerit points. That brings it down to 5, 9 to 5. And at that point, I'm good. I don't think that that the fact that the December 7th, 2012 Justice Court items were on there is really going to make any difference, because I do believe that it wasn't final, and so it's my way I think they shouldn't have been on that letter, but it doesn't matter. That takes it from 9 to 11, and we're still at 9 if we just ignore those. So now that brings us, what happened was that Justice Court decision got appealed by counsel and his client, Mr. Felton, and it took another year until November 5th of 2013 for the district court to basically affirm that appeal. Now, I guess now going through my mind, I'm wondering, there was probably an appeal period for that. There's probably a period of time that the Mr. Felton had an opportunity to appeal that decision. I don't know if we talked about what that period was, but my guess is it's probably 30 or 60 days. But what the procedure of the department is that they apparently, as soon as a decision is made like that, they issue their letter. I'm not sure if that's advisable, but that's what they do. I would think that they would want to wait until it's final, but again, the facts are that the department issued their letter, I believe, on November 14th of 2013. Council then writes a letter on November 26th of 2013. It's received on December 4th of 2013. And the way the statute reads is that now there's 60 days to set the hearing. And that could have been done, could have been put on the agenda for the January 31, February 1 commission meeting. But the parties got on the phone pursuant to the letter of November 26th, dated November 26th, to continue it. And apparently, they did that verbally. But NAC 501.175.1 deals with continuances, and it says that the only way that a hearing may be continued once is by written stipulation with the appellant and the secretary of the commission, which would have been Director Wadsley. And the department indicates that there were no further letters or anything that we could, construe as a stipulation. So I think that's where we're at. And our job, as I understand, is to see if the department has followed procedure. This is procedure. And so now what we have to do is we have to decide whether we can, look away from this NAC 501.1751. I think our job is to determine whether the procedure was followed, unfortunately.
Commissioner Young?
I see your point, Commissioner Macbeth, but I also believe Chief Bonamici when he says that he has consulted numerous DAGs over the course of the year about the scheduling, and has always gotten the advice from the DAGs that if both parties could agree to that you could do that. As in a law enforcement business for 30 years, and that's standard practice between attorneys and police officers and DAs quite frequently, as long as both parties agree. And I believe it was the appellate's attorney who first called or wrote the letter requesting to move this. And knowing Chief Bonamici and how he tries to accommodate people and work with people, I'm 100% behind him on this.
I guess where I'm at on this, in terms of the license and the proceedings, whether we would have heard this in Vegas or whether we would have heard this today as we are, the demerit points in my mind don't change, and the math to me makes sense with the 23. And so, while maybe there should have been something in writing, does it change what really is underlying the revocation of the license, which is the 23 demerit points? And at least in my mind, at this point, it doesn't.
Commissioner Lane?
I would agree with that assessment by Commissioner Drew. I mean, if you go through the numbers, the 5 points, it's pretty clear that this was taken into consideration. That's not my issue at all. But I would go back to this issue and I would say that you have this petitioner living in Fallon. For them it was a clear deal that the Reno meeting would be much easier for them than having to fly, drive into Reno, which is what they probably did today, and then fly down to Las Vegas. So, I mean, I understand the issue, but it wouldn't have been an issue if you had something in writing on the date, agreeing with the date, even if it wasn't signed by the director. Would that make the situation better for you? Yes.
Well, as a factual matter, I think clearly council waived the period. And so the question is, from a legal standpoint, and what we are able to do, can we then ignore 501.175.1 and say, notwithstanding that, it requires a written stipulation from the Secretary of the Commission that we go ahead and accept the letter of November 26, 2013 as a waiver of that. And now what we're doing is we're going beyond the laws, the NAC, and we're kind of adopting an equitable type remedy. And while I agree and feel it's right, I'm a little concerned that that if we adopt that position, I would assume that Mr. Wright is going to appeal this, our findings, and the basis will be that this wasn't followed. Now, whether he, whether in the end, we are supported that there has been a waiver and we can rely on this letter to waive this. I really don't know where that's going to go. That's the issue. We're down, everything else, the 23 claims, everything else is rock solid for me right up until this. And so I'm conflicted between the waiver that occurs on the November 26, 2013 letter and the subsequent phone calls that counsel himself admitted to. Even though he clearly indicated he didn't know what the law was, I'm not going to, I don't think that is going to go very far as a defense, but I think the question will be is, do we have, as a body in this hearing, have the authority to basically not follow 501.175.1 and go with the waiver that occurred on the November 26, 2013 letter plus the phone call. So that's where I'm at. And my gut feeling is that we've got a little bit of a window that's going to be opened up if we do that. But I do believe we have a basis to at least argue that there's been a waiver. Whether we have, that's why I asked the question of the DAG is, because it does seem like that discretion occurs under NRS 233B. But that's why I asked the question, well, if there's conflict, which one controls? And the DAG indicated the specific NAC ours controls. And so that's what I think is going to be problematic, for the commission. If I assume that Mr. Wright, on behalf of Mr. Felton, will do that. So that's what we have to keep in mind as to the possibility of adopting the waiver argument. And so therefore, do we have the authority to do that? And we can take the position we do because it's the right thing to do, and we can, make a decision, and what's going to happen is going to happen.
Commissioner Bliss.
I just have a quick question, and maybe that you can clear it up. This first time I've said in something like this, but if this ruling was to be overturned, what would happen to the demerit points that have been acquired already? Do they just sit there at 23 because the violations have been by law? There's been a ruling on it and everything. That's what it is. They don't just go away, would they?
Well, I think where's that statute again? I was looking at that very. Where's 1816? Here it is. what it says is, under 501.1816, it says, not less than 60 days after the department determines that a person has accumulated 12 department points, the department shall notify the person by certified mail that the person's privileges will be suspended or revoked. Except it's up to provided in subsection 4, the department shall suspend or revoke such privileges 30 days after it mails the notice. The problem is that if this decision is overturned, we are now going to be well beyond that 60-day period. I don't think it's been stayed. Let me think about this. Then you go on to 4, and it says, any person who receives notice, and see, we get right back to the 60-day, the hearing must be held. So I think if it gets overturned, I'm not sure if we're gonna be able to, I don't know if the department's gonna be able to come back. Maybe the DAG can weigh in on that. That's what he thinks, but I'm concerned that, it's water on the bridge, it is what it is, but if the department wants to do that, the next argument is going to be is that these are the procedures and they weren't met.
May it please the Commissioners, Board. Harry Ward, Deputy Attorney General. I would prefer not to
Speculate.
give advice during the deliberation period. I would say just let these deliberations be open, and then from there, both parties will deal with whatever the deliberations are. I just feel uncomfortable giving advice during deliberations.
Okay. I guess to answer your question then, Commissioner Bliss, is that the way I read the statute, I'm not sure who the department would be able to do anything about that, but I am not certain on that. And so I would need to spend some time with it, but when I just walk through the dates, the department made a determination, they had 60 days since the letter they did, the hearing didn't get held, and then it stops. It says, that's the procedure that should have been followed. If it wasn't, I'm not sure that the department has any additional authority to reissue another letter. But yet the letter that's there, is good, but then the hearing wasn't set. So I think there's some concern there.
Any other commission comments?
I guess my only question is we really are very limited in what actions we can take if we don't move forward with assuming or just saying, as you just pointed out, well, sometimes you just have to move forward. I mean, because we really, there's not a lot of other options other than not to take any action, and yet we all agree that, clearly these demerits, they're there. It happened. The issue is the whole hearing process. So, I guess my sense is we probably should just move forward. And then, as you indicate, whatever happens will happen. It's kind of like, you've got somebody and they get out on a technicality. That basically, that's what I'm seeing happen right now, and I just think that we have to move. I think the commission has to move forward. I think it seems to me that there is agreement in terms of, what the demerits are, and the hearing process. If the hearing process is the issue, then it's going to, whatever happens is going to happen.
Okay, and where I'm at, like we've been stated, the math all adds up the same for all of us. Everything adds up. We're gonna revocation was proper at the time. The only gray area is the hearing. And where I'm struggling with the gray area, the hearing, it wasn't the department's decision to hold off. It was the appellant's decision to hold off. And that's where I'm struggling is, I think the department did everything right, top to bottom, and it was the appellant's decision to hold off. It's just to dotting the i's and crossing the t's that leave a gray area on 501-175. So, I also do believe in what Mr. Young said with his knowledge of law enforcement. This is a routine type event that happens between legal counsel and law enforcement. Everybody, you agreed to hold stuff off. So I think there was an agreement made which leaves it less gray, starts shading towards black and white for me. So.
Your motion.
Go ahead.
I'd like to make a motion, Mr. Chairman, to deny the appeal of Mr. Felton regarding the revocation of his license.
Procedure.
Will deliberate and render orally its order with separate stated findings of fact and conclusion of law. So how does that spell out in motion?
Well, I don't think it's a motion. I think there is a, I think what we do is we have to probably have some way of determining, take a vote as to what, what the commission finds, and then have to do findings of fact and conclusions. Does that sound right? So I think,
Mr. Chairman, I'll withdraw my motion then.
Okay. So, we've deliberated, render orally its order, separate stating findings of fact and conclusion of law.
I think we probably do need to vote as to, what is our order going to be? Are we going to basically approve the license revocation? This is a revocation. Are we going to approve the license revocation? Are we going to issue an order approving the license revocation?
I think it's already been revoked, this is an appeal on that, correct?
Yeah.
That's,
Doesn't the commission have, doesn't the commission have to basically approve the department's revocation? Issue an order approving the,
And
the way I read that.
we also have a motion to dismiss that was entered at the beginning as well, correct?
May it please the commission, once again, Harry Ward, Deputy Attorney General. I'll just read some of the statutes and as well as the NAC, and I'm referred to NAC 501.165, as well as what I've also read at the beginning was NAC 501.185, that the commission will deliberate and then render orally its order with separate stated findings of fact and conclusions of law. In your regulations, I cannot find anything that tells you exactly how to deliberate, but I know in the open meeting law you have to do it openly, which you have been doing. I would think that there would have to be some sort of vote before this commission to make a determination by a majority as to what the decision of the commission is going to do. At that point, then I think you've concluded with your deliberations based on your majority vote, and then you would orally dictate it into the record, your findings of fact and your conclusions of law, whether it be I feel that this does not apply, or this applies because of this reason. That would be my suggestion to the commission. Now I'm just going to go back to NAC 501.165, and I said this beginning, this is hearing de novo, which means all over. And it says, 1, except as otherwise provided, subsection 2, a hearing regarding a denial, revocation, or suspension of a license or permit ordered pursuant to the provisions of chapters 501 through 506 inclusive of NRS, and any regulations adopted pursuant to those chapters will be conducted by the commissioners as a hearing de novo. I mean, hearing everything over. 2, at a hearing conducted pursuant to this, NRS 501.1816, the commission will, A, allow to be presented only evidence that is in the record regarding the suspension of revocation of the license, permit, or privilege that is on file with the department, and B, consider only allegations of procedural error committed by the department that affected the subsequent rights of the appellant. And I think that's what I enumerated on at the beginning. And I think that would be my recommendations to the board without giving legal advice concerning your deliberations. I don't know if that muddies the water more or clears it up.
Go ahead, Commissioner McBeth.
Okay, then I would like to propose a motion for an order. Well, let me do this first. I'd like to propose a motion to deny Mr. Felton's motion to dismiss as one, and 2, move that we uphold the revocation of Mr. Felton's hunting license for whatever the period of time is. I'm not sure. But anyway, just uphold the department's revocation of his license, period. That would be the motion.
Okay, we have a motion. Do we have a second?
I'll second that, and I'm assuming that's based on the finding or the determination of this commission that the demerit points were properly applied.
Right. And I think that's all baked into that we're just upholding the department's revocation. In other words, that their county points is right.
Okay, we have a motion and a second. Any further discussion? Seeing none, I'll call for the vote. All those in favor signify by saying aye.
Aye.
All those opposed? Motion passed 7-0 with Moore abstaining and McNinch